Rands, I just pressed the Let's Go Live button. So let's wait for the stream to fire up all across the fruited plain of the internet before we go ahead and get started. It's Friday, but we're not done yet, baby. We've got some business to attend to today. And it is going to be a doozy, but we can't really get into it until, we can make sure that it's working. Looks like it is working, which is tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney broadcasting from the Valley of the Sun, deep in downtown Phoenix, Arizona. And today we're talking about subpoenas. In fact, we're talking about a lot more than subpoenas. We're also talking about Donald Trump asking Congress for help. We are also going to be looking at a motion from Jacob Chansley, but we've got some serious business to attend to in Congress because Jim Jordan is in charge of the Judiciary Committee. They had an interesting hearing yesterday, which we are going to go through, involving the Department of Justice, Office of the Inspector General. This guy right here, Michael Horowitz, was in front of Congress, got asked several questions about the data collection and the censorship that was being done by various agencies and intelligence agencies throughout our federal government. And so we'll go listen to several of the bits from these guys. Let's go ahead and fix this little typo here. I'm so embarrassed. So we've got that. Then we are going to take a look at several different subpoenas that went out, and those are going to Rochelle Walensky, Jen Easterly, and James Rubin, all courtesy of the U.S. Congress. So we'll go take a look at those. As I mentioned, Donald Trump is asking Congress for help. We had some setbacks for the former president. He lost his appeal to stop Mike Pence from testifying in front of the special counsel, the special prosecutor, and the special prosecutor has actually already completed this. So apparently Mike Pence was already in there and testified, and so we'll take a look and break that down. And then Donald Trump and his team, his lawyers, they sent a letter over to this guy. He is the chairman of the House Permanent Select Committee on Intelligence. His name is Mike Turner. And so they sent a letter over to him, and we'll read through that. Donald Trump is saying, you guys got to do something about this. We're getting blown out here by the executive branch. Help. So we'll go into all of that in that second segment. And then finally, we've got a new filing on Jacob Chansley. The motion came out from Shipwreckedcrew. If you're on Twitter, you can give him a follow. The attorney who actually filed the motion is a pretty prolific Twitter person, and so you can hop on there and follow him. But he actually submitted this motion on behalf of Jacob Chansley. It's a motion to correct the sentence. So I want to go through the statute and then also read through the filing, because it is an interesting mechanism by which if they can prove that there was a constitutional violation or some sort of catastrophic error with this case, the argument is Chansley's sentence, maybe the entire judgment, the conviction, should be set aside entirely. So we'll go through that. We were expecting something like this to come, and boom, here it is. And so we're excited to dig into that. And my friends, if you want to be a part of the show, an amazing way to do that is by heading on over to watchingthewatchers.locals.com. We're going to do extra debrief on all of these topics and more after the show's over. We have an after party. And so if you're a member at watchingthewatchers.locals.com, you can join us, and you also get extra member-only morning streams. And we didn't do one this morning because we were over at Allison Morrow's channel, by the way. So shout out to Allison Morrow, who invited us over there. If you want to catch our conversation, we were talking about the Proud Boys. And so we're very grateful for the invitation to our friend Allison. And Allison Morrow is on YouTube. She's on Rumble. And we had a good conversation with her. I had some technical problems, but don't you hate it? But we had a great conversation nonetheless, talked all sorts of Proud Boys. And so check her out at her channels. And thank you, Allison, for the very nice invite. We also want to invite you to join us on YouTube. If you're a YouTube member, don't forget to grab our private Telegram group link so you can chat with other members before and after the streams, because even though the live stream ends here, the show will go on and on in our private chat. We also want to be properly fortified. We've got 3 segments today, boy, and it's got a lot to get to. So we all want to be healthy and fortified, and we all also would like to lose some of those extra leftover pandemic pounds. You know those pounds I'm talking about. We've all got a couple of them. But how sick are you of all the ads for the weight loss pills and the fad diets and all that stuff? You know, we've all been there. We have all done that, but we just know they don't work. But you know what does? Eating 5 healthy servings of fruits and vegetables every day. You do that, and the weight would probably just fall off. But vegetables, not a fan. And fruit, who's got time to prepare that every day? But let's talk about a better option. Field of Greens, baby. Field of Greens is a science-backed formula, very specific fruits and vegetables you won't find in any other product. Proper nutrition reboots your metabolism so you burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you're going to look healthier and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor says, wow, whatever you're doing, you look amazing. You've lost weight and keep it up. So let's get you started. Go on over to fieldofgreens.com. There, you'll find a whole smorgasbord of all sorts of amazing things. Field of Greens, you'll find stuff for weight. You'll find stuff for your joints, stuff for sleep, stuff for energy. Fieldofgreens.com. Save 15% with code Robert. And remember, my friends, the vegetables want to be eaten. And you can buy some for your mother this Mother's Day and say, Mom, eat your vegetables. We want you to be healthy and live a long time, all right? Be healthy. Shout out to all the moms out there eating their vegetables. All right, and so now let's get into the meat and potatoes on the day. And Facts Matter over on Locals says, you know, all this vegetable talk, it feels like you're kind of being pejorative against bacon. Was that what's happening here? No, I don't. I never mean to discriminate against bacon. I would never do such a thing. Let's get to it, my friends. Jim Jordan sends 3 subpoenas to Biden administration officials. You can see some of those individuals here on the screen, and we're curious to see how they respond. You remember this one. Dr. Rochelle Walensky, CDC director. You know who she is. She got a subpoena along with Jen Easterly and James Rubin. And these people were in charge of some pretty important agencies that have popped up all over the place, including the Twitter files when we talked about the Global Engagement Center, which was responsible for interfacing with a lot of the social media companies talking about Ma Russia everywhere you look. Jen Easterly, also from the Cyber Infrastructure Security Agency, the same agency that used to be held and housed, directed by Christopher Krebs. That same Christopher Krebs who wants lawyers disbarred for representing Donald Trump. She's in charge of this agency. And so all 3 of them got subpoenas, and we are going to take a look at the various subpoenas and see what Jim Jordan is asking for, because it relates to censorship. It relates to the controlling of the narrative that we all remember. We were living here. We were streaming through this. We were facing the YouTube backhand for coming on here and offering a different opinion. And so now the question is, in the aftermath, all this catastrophe that we are trying to piece together, what the heck happened here? Congress is taking some action, and we're very curious to see what the CDC has to say about it. But this comes on the heels of another report delivered to Congress, Jim Jordan and Matt Gaetz in particular, from the Department of Justice, the Office of the Inspector General, which is an independent investigator who's looking into data collection and censorship problems throughout this agency. Michael Horowitz has been doing a deep dive on this for quite some time, and he was joined by 2 other people to talk about this in front of Congress. You see their name, we're going to meet them. Their names are, oh man, I can't zoom in to show you the names. The names are, here it is, Sharon Franklin and Beth Williams. Sharon Franklin is the chair of it's called the U.S. Privacy and Civil Liberties Oversight Board, which I didn't even know was a thing, but apparently we have it. And so we're going to hear from Michael Horowitz and 2 women, one called Sharon Franklin and one called Beth Williams. And they're from this oversight board watching over privacy and civil liberties. And I love the sound of, I love the actual oversight and protection of civil liberties. Oftentimes they don't actually do the things they say that they're protecting, though. Well, we'll see here. We're going to go through a couple clips. We've got one from Matt Gaetz and one from Jim Jordan. And they're talking about data collection records. And this was a very interesting clip. Matt Gaetz posted this one. He was asking questions directly to Michael Horowitz, the OIG, the Inspector General. And here's what it sounded like.
I want to get into the 3.4 million backdoor searches that the ranking member pointed out in his opening statement. Mr. Inspector General, how should the public think about those?
Well, I think what we've seen in the various public reports, and I'm limited in what I can say about what's public, which I think is one of the issues, by the way, that's worth talking about is transparency here. It's obviously very concerning that there's no volume of searches, and particularly concerning the error rate that was reported on in the last 2 years in the public reporting. Now,
That error rate was what?
I believe it was around 30%.
30%!
I think it's around 30%.
30%. I'm a lawyer.
Can't hear?
I'm a mathematician, but 3.4 million, about 30%. You're talking about 7 figures of error.
The audio is low on that?
The searches. I'm wondering how many people can perform these backdoor.
The audio is muffled and distorted, you're saying.
Queries.
I'm going to defer to board members because you have the review ongoing.
I'm afraid I don't have those figures at my fingertips in terms of the number of people that can conduct those types of searches. But I share the concern of the question that we need to have greater safeguards, and I urge Congress to incorporate a requirement for FISA court review of these kinds of searches to protect Americans' Fourth Amendment rights.
All right, so apparently you guys can't hear that. Can you hear this one?
Ms. Franklin, you testified you have no idea how many Americans are picked up in the incidental collection, and the FBI won't tell you or won't even give you an estimate what that number may be. Is that right?
That's correct.
And you have no idea.
Okay, well, guess what? That segment is over, so we're not going to listen to those people anymore. I don't know what that problem is. All right, moving on. So, Jim Jordan sends 3 subpoenas to Biden officials. We know them as Dr. Rochelle Walensky over from the CDC, Jen Easterly, and James Rubin. And the subpoenas came after several letters were drafted. The first one from Jim Jordan on behalf of the Judiciary Committee. Ranking member Jerry Nadler got a copy of it, but this is from Jim Jordan. From the Committee on the Judiciary, April 28th, sent to the director of the CDC, Dr. Rochelle Walensky. Says, Dear Dr. Walensky, the Committee on the Judiciary is conducting oversight of how and the extent to which the executive branch has coerced and colluded with companies and other intermediaries to censor speech. Footnote 1, see generally an article from The Intercept posted 2022. Says to develop effective legislation, such as the possible enactment of new statutory limits on the executive branch's ability to work with social media companies and other companies to restrict circulation of content, the Committee on the Judiciary must first understand how and to what extent the executive branch coerced and colluded with companies and other intermediaries to censor speech. So we want to know what you have done to get here. To this end, we have asked for communications between the CDC, private companies, other third-party groups, other nonprofit organizations, in addition to other information. Your response without compulsory process has, to date, been inadequate. Saying we've already asked for your voluntary compliance on this. They write that the Twitter files and other public reporting have exposed how the federal government has pressured and colluded with big tech and other intermediaries to censor certain viewpoints on social media and other media in ways that undermine First Amendment principles. And of course, if you're watching this, you are very likely a person who has seen other content creators, other people on the internet be censored, deplatformed, some people debanked, some people prosecuted for saying things and doing things that in prior eras would be considered free speech or would be non-prosecutable. The First Amendment prohibits, they continue, government officials from imposing viewpoint-based censorship. Meaning you can't say that one person is allowed to say something because they have a different viewpoint. The debate must be open and viewpoint neutral if you're going to limit conversations. The state doctrine stands for the proposition that government officials may not circumvent constitutional strictures by using private actors. In other words, you can't outsource your censorship. The First Amendment applies to the government, and if the government is outsourcing that, they're saying, well, we're not censoring anybody. Twitter censored it, not us. And if Twitter censored it, then the government is immune because they did it of their own volition. Well, that's not true. We saw that the government was acting and basically twisting their arms into doing it, saying we want reports, we want updates. And there's a number of Twitter files, and we've covered most of them, except the last 2 or 3. So you can't outsource it, whether through coercion, through encouragement, through entwinement, through joint participation. You can't do that to accomplish what the government cannot do directly. Saying numerous documents made publicly available reflect the weaponization of the federal government's power to censor speech online, directly and by proxy. Saying it is necessary for Congress to gauge the extent to which the CDC coerced, pressured, worked with, or relied upon social media and other tech companies in order to censor speech. The scope of the committee's investigation includes understanding the extent and the nature of the CDC's involvement in this censorship. What kind of pressure were they putting on YouTube? We got medical misinformation strikes here. We got a medical misinformation strike for the Joe Rogan debate when CNN was saying he was using horse dewormer. And we appealed that and won. But I think another one for medical misinformation struck at some point. On March 22nd, the committee wrote to the CDC seeking voluntary cooperation with our oversight. Can you please cooperate with us? We're Congress. Can you work with us? Among other things, we asked for simple communications between the CDC and private companies. What were they saying to Twitter and Facebook and Google and YouTube? We also wanted internal CDC communications and communications between the CDC and other third parties discussing content moderation. But to date, the CDC has failed to produce any documents responsive to the committee's request. Saying, pursuant to the rules of the House of Representatives, the Committee on the Judiciary has jurisdiction to conduct oversight on these matters concerning civil liberties to inform about legislative reforms. In addition, our House rules, H.R. 12, and the Select Subcommittee on the Weaponization are authorized to investigate issues related to the violation of civil liberties of citizens of these United States. And so accordingly, and due to the CDC's inadequate voluntary compliance, Walensky, please find attached a subpoena for you. Very sincerely, your friend, Jim Jordan, United States Congress. That was submitted on April 28th. And she's not the only person who got one of those. A couple other people did too. Jen Easterly got a nice little note on this Friday. April 28th, also from the Committee on the Judiciary. Basically the same letter. And so let's see if we can tease out anything unique about this, because this is a different agency. What did they do? CISA, we listened to a lot of them. They were telling us about infrastructure and about elections and about no evidence about things and all sorts of stuff. And we heard Christopher Krebs, I think he had the kind of long hair dude. You know, he's kind of like broed out a little bit. And he was talking to us all about utmost secure. Remember, what did they say all the time? Most secure in history, something like that. Most secure in history or something. All of these people were a part of these agencies. They came out and they put on their suits and ties. And they said, no. So they write to this agency. Now, he's not there anymore, but this is the new person in charge. Her name is Jen Easterly. The Committee on the Judiciary is conducting oversight. Executive branch is involved in this. We have asked for communications from CISA and other private companies. Your response has been adequate. The Twitter files show you guys are involved in this, and numerous documents made available show that you have been involved. And so it's necessary for us as Congress to gauge the extent to which CISA pressured other social media companies to get involved. We wrote to you previously in March asking for voluntary cooperation. You have failed to respond. We're authorized to investigate this. Accordingly, you get your subpoena. Jen Easterly, enjoy it. Please find attached a subpoena. Courtesy of your friend, Jim Jordan. And she is not the only person, the last person, and you know this name because we've talked about this person here a bit, in particular related to the Twitter files, but Special Envoy and Coordinator of the Global Engagement Center. This was one of those weird agencies that was sort of created underneath the wing of the State Department that was really focused on foreign misinformation and stuff pouring in into the case. They write, Dear Mr. Rubin, the Committee on the Judiciary is conducting oversight of how and the extent to which you have been involved in restricting content and deplatforming users. The GEC has not responded appropriately. Numerous documents show you're involved, that you may have pressured, coerced. Okay, nothing actually interesting to extract from this one. Same thing, Mr. Rubin, you get a subpoena too, courtesy of your friend, Jim Jordan. So 3 different subpoenas go out to 3 different agencies. People in the Biden administration all getting those, and we'll see what they do. We'll see how the response looks from the executive branch, whether they comply or whether they challenge them in a court of law. But more will be revealed. The good news is that Jim Jordan's doing something. We like to see that out of Congress. And in this case, the Republicans are exercising the same powers that the January 6th Select Committee exercised. They were out there saying, well, we can basically do whatever we want. We passed a House resolution that created us and gave us all sorts of power. And there were no courts that wanted to get involved and interfere with the internal operations of Congress back then. So the Select Committee had full reign to do whatever they wanted. And censorship and the First Amendment are pretty important issues to Americans. It's the First Amendment for a reason. And so if Congress decided to give themselves authority to go investigate why government entities are outsourcing their censorship efforts to third-party private companies and thinking that's acceptable, Congress may want to get involved in that to make sure that doesn't happen again, which would be a good thing. Because how can a democracy, as they like to say, function when a country that has democratic principles is layered upon free speech? Happens to be the First Amendment, but they don't like it. They think that it challenges the narrative, and so they'll create structures to try to clamp down upon it. Jim Jordan is going to investigate it. Of course, we'll continue to cover. Now, let's move on. We've got a whole nother segment here. And this one involves Donald Trump. Trump asks Congress for help. He's getting some bad news from various courts in this country, and we can't really peer inside to see what's happening because they're being conducted in private, under seal. But we do have some headlines from reporters who are lurking about getting the news that leaks out from the Justice Department. Axios reports telling us the following, that Donald Trump loses the appeal to stop Mike Pence from testifying in the January 6th probe. And zooming out for a minute on this, remember that Donald Trump really has 3 different broad prosecutions that are taking place right now. He has the one that's active, which is out of Manhattan. He has the second one, which is probably coming in July out of Georgia from Fani Willis. That may be a big slew of indictments. She's talking about RICO and other things. But the third, and what I've always thought is the most serious level of prosecution against the former president, is going to be coming from the special counsel's office. And in particular, it's investigating 2 different facets. One is the Mar-a-Lago confidential documents element, so a bucket of investigations taking place related to that, and all the criminal statutes they allege may or may not have been violated there. And the other investigation is related to January 6th and any of the so-called interference with democracy and that area of the law. We've been spending a lot of time talking about that with the Proud Boys, and we've been speculating that maybe there will be a connection between a potential Proud Boy conviction and Donald Trump for seditious conspiracy. And so I've always thought that the federal prosecutions are going to be the big ones that act as the keystone that kind of brings everything together for this effort to stop Donald Trump from moving forward. And very slowly, but very surely, the federal courts have been ruling against Trump. This was a pretty big one. Trump loses the appeal to stop Pence from testifying. You see, they tell us that Trump filed an emergency application to block Pence from testifying before a grand jury. This is the same grand jury that the special counsel has created to pursue these claims. Why does this matter? They say Pence is a key witness. And the U.S. Court of Appeals for the D.C. Circuit Court, there was a sealed ruling that may make it possible for Pence to testify. And guess what? Pence did testify. So as soon as that appeal came down, Pence sat with the grand jury. And we know Mike Pence is an interesting character because he is trying to tread this line between not wanting to alienate the Trump base, which he may think for some reason might vote for him, and I would estimate sideline Donald Trump to remove him from the field because, like all politicians, they are all in it for themselves to some degree. And Mike Pence would be well served if Donald Trump was ultimately sidelined. So here we see that CNN tells us that the former Vice President Pence did testify to a federal grand jury that's investigating Trump in January 6th. So the question is, what did Mike Pence say to them? On Thursday, he testified in front of a grand jury talking about the aftermath of 2020. Marks a momentous juncture in the criminal investigation and the first time in modern history that a vice president has been compelled to testify about the president that he served beside. Pence testified for more than 5 hours, a source familiar with the matter said. Pence tried to say he was immune from testifying. He said he was pleased that for the first time a judge acknowledged it, but he was willing to comply with the law. It says Pence was poised to recount for the first time under oath direct conversations with Trump leading up to J6. So what did Pence say? Trump repeatedly, according to CNN, pressured him to block, including with a morning phone call. Pence's meeting with investigators come as he's exploring a possible run. His testimony could harm Trump and it could help him, meaning Mike Pence. Pence frequently speaks about refusing to do Trump's bidding. The grand jury was in Washington, D.C. The proceedings are secret. They assembled before 9 a.m. on Thursday. That coincided with an increase in security inside the courthouse, and then 2 SUVs with tinted windows were spotted ferrying people to the building. A spokesman for the special counsel, Jack Smith, and a spokesman for Pence both declined to comment. Both Pence and Trump went to court to try to stop this from happening. But the latest decision refused to give Trump emergency help. The case has put Pence in a unique position. Got to define powers from his former office. And so this is heating up, as you can see. Pence declined to testify before the House Select Committee that investigated what they still call the insurrection, which is hilarious. And Pence and Trump did not speak during the attack, they say, and we're getting to the end of the article. Pence wrote a book. Neat. All right. So now that Mike Pence is testifying, and now that now that the executive branch seemingly has all the witnesses that they need, Donald Trump is asking Congress for help. And he sent a letter, his lawyers sent a letter over to Mike Turner, a Republican from Ohio. And Mike Turner, as you can see, is on the House Permanent Select Committee on Intelligence. And so they're drafting and sending a letter over to him asking for some input. You can see this letter comes from Trump's lawyers, Timothy Parlatore, being sent to Chairman Mike Turner, House Permanent Select Committee on Intelligence, dated April 26, 2023, from the Parlatore Law Group. They say, "Dear Congress, we represent President Trump and we're writing to provide information regarding a probe by the DOJ into the post-presidency handling of classified documents. They say, we understand that the DOJ is making the documents that were marked classified available for your review, and this letter provides the committee with information that we think that the DOJ has not disclosed to it." Uh-oh. So this is like a warning letter from Trump's lawyers. And you see some of this stuff in grand jury proceedings sometimes when an investigation is taking place. You might see a defense attorney send in a letter that explains the other side of this and explains that the evidence has an alternative context that might be valuable in the charging decision. So this has the feel to this. They're saying, hey, look, Congress, if you're investigating all the documents that were at Mar-a-Lago, you need to know this other side of the story. They say it has become abundantly clear that through this investigation that the institutional procedures within the White House for handling classified materials differs from the long-established operating procedures employed by various agencies. They say, as demonstrated by the discovery of documents in the homes of Trump, Biden, Pence, deficient document handling is not limited to anybody. Okay, everybody's involved in this document problem. So they say that a legislative solution by Congress is required to prevent the DOJ from continuing to conduct criminal investigations into matters that are inherently not criminal. Seeing that asking Congress to create a broader solution because a broader solution is necessary. Documents are a problem in general. And so if you criminalize, again, we talk about equal standards here. If you're going to criminalize Donald Trump, why are you not criminalizing Biden and Pence? It's because there was some cooperation there. But the problem remains. And so maybe they should address the problems and the disagreements about how to handle the classified documents rather than just charging people with crimes. Saying the purpose of this letter is not to opine about whether the documents are actually classified or any of those things. Despite our request to the DOJ has refused to tell us whether its judgment of any of the documents remain classified. Similarly, the DOJ refused to allow the inspections of the documents at any time during the last 8 months, despite the fact that one of our attorneys has clearance to see these things. So they're also telling Congress, they're saying, look, you're going to look at all these documents, okay? We can't even see what's in there to explain them all for you. We have clearance to see them, but they're not letting us see them. And in addition to that, you should have some context that this is a much bigger problem. They give us some facts. They say when President Trump left office, there was very little time to prepare for the outgoing transition. Unlike his three predecessors, each of whom had over 4 years to prepare for their departure upon completion of the second term, Trump had a much shorter time to wind up his administration. White House staffers and other employees quickly packed everything into boxes and shipped them off to Florida. This was a stark change from the standard preparations made by the GSA and NARA, the head librarian agency, for prior administrations. So they say NARA had a different approach with Trump. As soon as Trump was going to be packing and thrown out, they're like, get out of here. They helped everybody else. The National Archives assumed physical and legal custody for Obama, for Bush, for Clinton, for HW, for Reagan. They helped all of those people. They set up temporary facilities and had strict archival setups and all of that stuff. But not here. They hated Trump. NARA, unfortunately, has become overtly political. And yeah, I mean, the head librarian is basically more powerful than the president, as we've talked about many times here, and declined to provide archival assistance to Trump and his transition team. They're like, just get your boxes and get the heck out of here. Interestingly, in its press statement, NARA cites every recent president after Carter as having received the same assistance. Yet Carter, the last president before Trump, not to receive archival assistance, found documents in his home, which he returned, but there was no criminal probe for him. So everybody has a document problem. And even Carter, they didn't help. He was a one-termer. So whether NARA's departure from routine procedures for President Trump was intentional or just a byproduct of a compressed timeline, it did not take custody of the documents, and this made the transfer necessary. And by the way, they went to Trump's heavily secured home in Mar-a-Lago. And to be clear, they say had NARA offered Trump the same assistance that it had given to all other previous presidents, he would have accepted the offer and there would have been no reason to transfer the documents to Mar-a-Lago. But they didn't offer to help. Says NARA and their variance, their deviation from the standard procedures, ignited a dispute with President Trump. They caused it when it discovered that boxes were being transferred to Florida. They're saying there was no discovery. There's no discovery there. You knew he was taking the boxes because you told him you were not archiving them for him. In January 2022, in an attempt to cooperate with NARA, Trump asked his staff to retrieve 15 boxes that had been moved to Mar-a-Lago so he could see what was in them before they were sent to NARA in D.C. However, due to other demands on his time, Trump subsequently directed his staff to ship the boxes to NARA without any review. Upon receiving the boxes, NARA opened them, reviewed their contents, and found that some of the documents with classification markings had been mixed in with other personal and presidential records. And so they continue. They say, us two lawyers, Tim Parlatore and Jim Trusty, two of Trump's lawyers, who are attorneys for President Trump, we reviewed all 15 boxes at NARA earlier this year. And based on that review, it is clear to us what happened. The lawyers say, the boxes contain all manner of documents from the White House. They're loosely grouped by date. They include newspapers, magazines, notes, letters, daily schedules. Following its review of these materials, NARA inserted placeholder pages where it had removed the documents with classification markings. That allowed me, Parlatore, and Trusty to discern what the documents were, as well as what other materials in the boxes were in the proximity of the marked documents when the White House staff packed them. The vast majority of the placeholder inserts refer to briefings or phone calls with foreign leaders that were located near the schedule for those calls. This organization of materials, for example, the schedule of the calls for the day, insert the page briefing to prepare for the call, indicates that the White House staff simply swept up all the documents from Trump's desk and other areas into boxes where they have resided ever since. Okay, so they're explaining like how the documents are layered on. On your desk at home, you've got your mail, oh gosh, more mail, more here, more, garbage here. And it's in your alignment, and then you put your keys on there or whatever you got. And so he's just saying there's a stack of documents on there, and just based on what it looks like, we can tell it was probably on Trump's desk. And they just threw it in a box and drove it down. It says Trump's lawyers say, our review of the boxes at NARA shows that the White House institutional practices for the handling of classified documents, including declassification procedures, are inconsistent with how the intelligence community and the military handles classified materials. This is indicative of the staff packing process, and there's not any criminal intent here. As such, this matter should have been immediately referred to the Office of the Director of National Intelligence or your committee, not the DOJ. The improper involvement of the DOJ in what should have been just an administrative investigation of the spillage of documents with classification markings should have been where this ended. led to the wrong course, and the current political environment has resulted with Attorney General Merrick Garland and the DOJ predictably choosing to pursue a criminal investigation. Saying any doubts that the process of the marked documents in the boxes was a result of institutional processes rather than intentional decisions should have already been dispelled. Saying that the recent discovery of marked documents in other presidents' offices show that. In other words, you can presume that Donald Trump didn't intend to criminally take classified documents. Why? Because you're saying the same thing about Pence. You're saying the same thing about Biden. If they have the presumption of innocence and the presumption of non-intentionality, non-criminality, why doesn't Trump? The possession of the documents by these two former vice presidents is similar in some respects to those that were transferred to Mar-a-Lago. Trump, like the outgoing VPs, was not afforded assistance from NARA and the GSA, and this resulted in confusion about what to do with the documents. The lawyers say, to be clear, Congress, our legal team has reviewed the entirety of the 15 boxes since their return to NARA, and we've supervised searches of several different locations, some of which have resulted in the production of a handful of additional marked documents. We have seen, though, absolutely no indication that President Trump knowingly possessed any of the marked documents or willfully broke any laws. Rather, all indications are that the presence of the marked documents at Mar-a-Lago was a result of haphazard record keeping and the packing by White House staff. Trump has directed us to immediately notify the DOJ of the discovery of the marked documents at Mar-a-Lago, and we have faithfully done so. They continue, they say the decision to have the DOJ rather than the Office of the Director of National Intelligence conduct a review of what happened is probably the executive branch's single biggest blunder in addressing this issue. As Abraham Maslow wrote in 1966, if the only tool you have is a hammer, it's tempting to treat everything as if it were a nail. Now, despite the availability of a far more appropriate support from the Office of the Director of National Intelligence, the involvement of the DOJ improperly predetermined that the matter should be criminal. They needlessly ratcheted up adversarial nature of this matter, resulting in a waste of time and resources and a loss of public trust. There's no legitimate purpose to this, and the DOJ's actions further erode constitutional rights while blindly compromising its own ability to provide a real account of what happened. From the inception of this matter, Congress, rather than working cooperatively to ensure the return of the documents, the DOJ chose aggressive combativeness. And by doing that, they compromised the evidence, they compromised constitutional rights, and they compromised their own ethics. They wanted to criminalize what should be a simple civil matter, resulting in an unprecedented investigation of a former president while bristling at transparency, desperately seeking to justify its abominable conduct. History will not be kind to the DOJ or the administration that supports this assault, while excusing much more serious conduct by the current president. Whoa. History will not be kind to the DOJ or the administration that supports this assault. Well, there's an interesting question here. What happens if Donald Trump is the next administration and the next president? He gets to create some of that history, doesn't he? If he wins the next election. This is not a passive situation. We're not just sitting around watching history. Donald Trump may very well be the person who gets to drive that bus. The best way to investigate, writes Trump's lawyers, how the marked documents found their way out of a controlled environment is to analyze where they were found with surrounding materials. Had the Office of the Director of National Intelligence investigators just approached Trump early on, it would have been able to work cooperatively with the Trump staff, and any alleged mishandling could have been resolved because there was no intentional wrongdoing. But the DOJ chose not to work cooperatively with Trump's team. Instead, they chose to fuel the animosity through an inappropriate use of criminal investigative tools like a grand jury subpoena on May 11th and a search warrant on August 8th. And do you have any doubt about that at all? If you have prosecutors in the DOJ and you're like, hey, can you be fair in the prosecution of Trump? Like, should you do it or should you not? Do you think that there's anybody in there who's like, yeah, I can be fair on this one? I mean, you know, at the higher up levels, I'm talking Lisa Monaco, Attorney General Merrick Garland, Matthew Graves, right? These type of people up at the upper echelons of the DOJ. Think there's anybody there who would have treated a Barack Obama investigation like this the same as a Donald Trump investigation, given them the same benefit of the doubt? No, the prosecutorial discretion went right out the window. By unleashing a grand jury subpoena, the DOJ intended to put President Trump on the defensive, not to invite his cooperation. The grand jury subpoenas seek only the disclosure of documents. In this case, any documents with markings. They do not provide any mechanism to document where those documents were located or what they were near, thus destroying the contextual evidence that is critical to understanding what actually happened. The DOJ unnecessarily, and their aggressive use of a grand jury subpoena was not intended to ensure compliance. When defense attorneys requested additional time from them, the U.S. attorney's offices generally routinely agree to a reasonable schedule, often including rolling production, to ensure full and complete disclosure. But here, President Trump's lawyer, Evan Corcoran, attempted to negotiate additional time and conduct a complete search. And then Jay Bratt, another one of them, the chief of the Counterintelligence and Export Control Section, initially agreed to extend the applicable time response. However, then he subsequently reneged on the agreement and rejected the proposed production and any rolling production. Now, ultimately, Trump and his legal team complied with their demands, performed a search, and completed it by the arbitrary deadline. They submitted a certification and affirmed the same. But to be clear, the certification stated that a diligent search was conducted, all responsive documents found were provided, not the search turned up all possible documents as they have falsely characterized. So if you remember, zooming out on this for a minute, we saw there was a letter apparently signed by Christina Bobb, one of Trump's lawyers, saying that we have conducted a search and everything that we have found has been given over to you. The media said that they said that means that everything had been found and we had given everything over to them. So when the FBI did their little raid of Melania's closet and they found new documents, they said, oh, see, you lied to us. That's obstruction. You told us you already gave us everything back. They're saying, no, that's not what we signed. The thing we signed said we gave you everything we found. Not everything there is. And saying the media has been manipulating that. Continuing, saying on June 3rd, several weeks after serving the subpoena, Jay Bratt and 3 FBI agents came down and met with Trump's lawyer at Mar-a-Lago, at which time Corcoran turned over documents found in other boxes. Trump popped his head in, told Mr. Bratt, said, hey, if DOJ needs anything, just ask the team. After which time, Corcoran showed the DOJ the room where the documents were stored. And although Corcoran told the DOJ representatives that they were not going to go through the boxes that day, he fully expected the DOJ to return to Mar-a-Lago and examine them. Mr. Bratt reinforced this belief 5 days later when he wrote back to Trump's lawyers, requesting an additional lock be placed on the door. The lock was soon installed. The box is kept under lock and key under a facility guarded by the armed Secret Service agents. Totally secure. So now my question is, is Mr. Bratt there from the DOJ, to go back to a prior point we were discussing here? Is Mr. Bratt, when he's rummaging around Trump's location, do you think he's there as a friendly person trying to help a former administration secure a facility with secure documents? Does anybody believe that? That he's sitting there going, okay, yeah, this looks secure. Mr. President, I don't agree with you, but we're here. This does look secure. And we've got our FBI agents. Trump pops his head in. Nothing, no problem at all. Trump thinks that he's still in alignment with him because they have allegiance to the U.S. government, to the United States of America, and there's even rules or even playing there. I don't believe that for a minute. I think that these FBI agents and the DOJ, every time they're there looking around, they're concocting a scheme on how they're going to prosecute this guy. Put a lock on it. Let's see if he screws that up. I put a lock on it. Okay, great. What other documents are there? And they're looking around at cameras. They're looking around at people. It's an investigation into Trump. He just gave him access to everything. They're basically there waiting for him to make a mistake. And then, boom, they can prosecute him. They form grand juries. They issue subpoenas. And the whole thing goes from there. Trump is oblivious to this whole thing. Hey, FBI. Hey, DOJ. You guys are here. Hey, what's up? Let me know if your team needs anything. At the time, President Trump and Corcoran understood this to be the beginning, not the end, of working cooperatively with Mr. Bratt and the DOJ to resolve any outstanding concerns. President Trump did not imagine that rather than accepting his offer, Bratt would abruptly discontinue the dialogue and seek a search warrant. He's like, oh, I'm here now. Okay, great. I see where all the crime is. Apparently eager to criminalize the document dispute with NARA. As we now know, thanks to reporting from the Washington Post, Mr. Bratt fought with the FBI to block any further cooperation with Mr. Corcoran. According to one news report, Mr. Bratt met with the FBI officials who, quote, repeatedly urged that the FBI should seek to negotiate a consensual search rather than conducting a surprise search. But according to the Post, tempers ran high in the meeting, and this DOJ Bratt raised his voice at times and stressed to FBI agents that the time for trusting Trump and his lawyer was over. The same article reported that Mr. Bratt urged the use of a search warrant as early as May, which speaks volumes about his desire to use criminal tools in the unprecedented and heavy-handed fashion that followed. So Trump thinks that these people, and this is a big mistake that I think Trump hopefully doesn't allow to happen again, but it's believing that some of these government agents are on his side. This guy, I think, was in there as the mole. We talked about the mole at Mar-a-Lago. It's the DOJ. The Washington Post article showing a clear effort by FBI officials to distance themselves from the conduct of Bratt and his team also stated that some FBI agents had then argued to prosecutors that they were inclined to believe Trump and his team had delivered everything the government sought. In doing so, they said the Bureau should close down the criminal investigation. Now, this is consistent with the demeanor of the field agents who met with Mr. Corcoran and expressed their gratitude for being permitted to inspect the storage room, which they acknowledged that most attorneys and their clients would not permit. Trump said, yeah, come take a look around, man. Everything's clear. The field agents are like, this is great. It looks good. Shout out to the good FBI agents. But then it goes back up to Bratt and all of the others at the upper echelons. And they say, we're going to prosecute this anyways. And when the FBI asked Mr. Bratt whether President Trump was the subject of a criminal investigation, Bratt reportedly replied, what does that matter? This was a stunning, disingenuous position for a DOJ attorney to take when advocating for the unprecedented search of a former president's home. In the end, Attorney General Garland endorsed Mr. Bratt's conduct by approving the raid, and then on August 11th held a press conference and failed to mention Trump's offer to cooperate regarding the return of the documents. They say to date, only a heavily redacted version of the search warrant affidavit has been made public. However, it is clear that the DOJ utterly failed to make an accurate presentation to the magistrate judge, meaning the search warrant was not accurate and honest. They violated Trump's constitutional rights against an unreasonable search and seizure. Woo! We love that here. That's some good defense attorney language right there. Yeah, love it. The DOJ, which is great because Trump's going to be indicted on this, and this is just the pretext. So they will very likely will be seeing more of this, probably in some pretty heavy criminal law in motion soon. Says the DOJ is likely concealed from the judge when they were applying to get the search warrant, meaning they didn't tell the judge that Donald Trump had offered his cooperation or that the DOJ team could have pursued a consensual search, as Trump basically essentially invited them to do. The redactions to the pages, paragraphs 56 and 57 of the application are telling, and they may well conceal distortions about the DOJ's interactions with Mr. Corcoran rather than actual sensitive information, saying that the affidavit is problematic because it's concealing distortion. The redactions are problematic. It's concealing distortions in the affidavit, not sensitive information. And if we see what it is, we're going to be able to rebut those distortions. So Trump's lawyers continue. They say, as President Trump's legal team moved to conduct additional searches for documents with classification markings, the DOJ's continued its pattern of prioritizing belligerence over investigation. They refused our invitation to have FBI agents observe our search, and this refusal, like the earlier decision to proceed by a search warrant rather than cooperate with consent, again resulted in the DOJ's inability to establish a clear chain of custody or evidentiary context of the document locations. So, in other words, they're wrecking Trump's defense by disallowing Trump and his team to observe or to be in participation with this through a consensual search. They're going in and gobbling these documents, and it's making it more difficult for Trump to establish a chain of custody. For Trump to say, hey, I didn't take that. I didn't have anything to do with that. It came from them to them to them. Those are all White House aides. There's no criminal intent here. And he can trace this all back to a certain box on a certain day. But the FBI came in and they gobbled it all up. So we don't know where it was in context. We have to take the FBI's word for it. And we know they're not on behalf of Donald Trump. Says, in an attempt to overcome its own failures, then the DOJ chose to compel Mr. Corcoran and the investigators hired by the legal team to testify before the grand jury concerning their memories of where the documents were found. They didn't need to do that. They could have just come in there and asked. This was clearly suboptimal and constitutionally a dubious substitute for what could have been a well-documented consent search. Would have located the documents in the same condition that they'd been collected and stored by the White House staff. And we could have explained it. But now we don't have that opportunity. Saying the DOJ's conduct of this investigation, as well as its persistent, often criminal leaks of this sealed investigation to the media, is antithetical to the principles of the search for truth. However, Trump's case is not the only instance in which the DOJ has demonstrated its unsuitability for such investigations. We're getting ready to call on Congress to do something about this. When documents were found in Biden's Penn Biden Center and the library, despite clear indicators that his violations were more likely the result of willful misconduct, the DOJ treated Biden very differently by foregoing any attempts at manufacturing conflict like they did with Trump, while implicitly approving the spoliation of evidence. The applicable criminal statute prohibits willful retention of documents, but to prove this, you got to prove that it was knowing. And Trump's team says, despite the media spin to the contrary, this is the key element that distinguishes President Trump from other people, including Joe Biden. Evidence of knowing possession can be readily inferred from the length of time that Biden possessed the marked documents. He left office and they were moved and stored at multiple locations. Trump's weren't done that way. They just left the White House and ended up at Mar-a-Lago. But Biden moved them around, picked them up. In comparison, the materials found at Mar-a-Lago were still stored in the same GSA boxes in which they left the White House, untouched in the relatively short time since the end of Trump's term. Perhaps the most damning fact for Biden is that he possessed marked documents from his time in the Senate, a body that maintains all marked documents in a SCIF, unlike the White House. Further, as you're no doubt aware, Congress, and as mentioned earlier in this letter, media reports have indicated that classified documents were contained in a folder called Personal, which is much more powerful evidence of knowing retention, knowing that you've got those documents, than documents being randomly dispersed into boxes by moving teams. So Congress, rather than learning its lesson from mishandling Trump's document searches, the DOJ repeated the same mistakes. They allowed Biden's private attorneys to conduct searches and turn over marked documents without any documentation of where or what they found. And that indicates knowing possession. It was widely reported that, unlike the search of Trump's home, the DOJ declined to attend, observe, or participate in any of Biden's searches. Instead, it chose to allow this key contextual evidence to be destroyed in a case that has far more indications of criminality. Similarly, it appears that Vice President Pence was also permitted to return the documents without DOJ and others. And so what is consistent in all three of these cases is that the White House procedures are flawed, and the DOJ is not the appropriate agency to get involved in any of this stuff. So Congress, we're asking for some input here. The solution to these issues is not a misguided, politically infected, and severely botched criminal investigation, but rather it's a legislative solution, and Congress should step in now. The DOJ should be ordered to stand down, and the intelligence community should instead conduct an appropriate investigation and provide a full report to this committee, as well as your counterparts in the Senate. And armed with the appropriate knowledge, we respectfully suggest that you, Congress, and your committee hold hearings and make legislative changes to do the following. 1, correct classified document handling procedures in the White House. Standardize document handling and storage procedures for presidents and vice presidents when they leave. And formalize procedures for investigations into the mishandling or the spillage of classified materials to prevent future situations where the DOJ is inappropriately assigned to conduct an investigation. If Congress wants the DOJ to investigate these types of situations, they can pass a statute to clarify that, to adjust the criminality, and prescribe methods for protecting national security. President Trump's legal team would be happy to meet with you, Congress, or your staff, and to assist in any way necessary to address these issues. Please know that despite the differences in these cases, we do not believe that any of these three matters should be handled by the DOJ. Rather, the stakeholders to these matters should set aside political differences and work together to remediate this issue and enhance our national security in the process. Very truly yours, a bunch of Trump lawyers here. Look at these. We've got Timothy Parlatore, we've got John Rowley, we've got James Trusty, and Lindsay Halligan all signing off on this. And we've got several people being copied. Speaker of the House, Kevin McCarthy, Hakeem Jeffries, Chuck Schumer, Mitch McConnell came in, along with Jim Himes, Mark Warner, and Marco Rubio, all in the Senate and in the House, asking Congress to get involved, to step in, to stop the weaponization of the Justice Department against Donald Trump. We'll see what Mike Turner says and what the special counsel does, but of course, we'll continue to cover this. Thank you for subscribing wherever it is you're watching, and we'll look forward to seeing you as we continue to cover. All right, my friends, and we've got one final segment on the day. And so let's get right to it. Jacob Chansley submits a new motion asking for a correction to the sentence. Now, Jacob Chansley is out of custody, and he has a new lawyer, and he is on Twitter at Shipwreckedcrew. And he submitted this motion on April 27th. It's 22 pages, and it's called a motion to correct the sentence. Here is what it looks like. And as we go through this, I want to reference back to this law, 28 U.S. Code 2255. We're going to understand what this law allows Jacob Chansley to do, what the process looks like after this is submitted, what the government can do to respond, and what potential outcomes might be for Jacob Chansley. But you see, this was submitted on April 27th. It's 22 pages. United States of America versus Jacob Chansley. And you're thinking, this case is closed. It's overdone. He's already served his time. He's got released. He's at a halfway house or at a different location, and he is done and past this, right? Let's see. The motion comes from William Shipley, as we talked about, is on Twitter at Shipwreckedcrew. And he writes, comes now the defendant, Jacob Chansley, through counsel, and respectfully moves this court to vacate, set aside, or correct his sentence. Here's the background. On March 6, Fox News host Tucker Carlson broadcast on his national cable news program taken of Jacob Chansley on January 6, It was captured by CCTV cameras and shown Jacob Chansley through various corridors and hallways inside the Capitol. The CCTV videos show that he encountered numerous officers of the Capitol Police over a long period of time, and he was even escorted by one of those officers as he made his way around the Capitol. The CCTV videos show one instance where an officer attempted to open a door for Chansley, only to find out it was locked. Another video showed an officer opening a door and following him inside onto the floor of the Senate. At no point in any of the videos shown by Fox News did the Capitol Police officers that Chansley encountered take Chansley into custody. They didn't impede his movement inside the Capitol. In fact, one CCTV video showed him passing in between approximately 6 officers who were standing on both sides of the walkway about 10 feet wide. None attempted to block his movement, and we've seen all the video there. By the government's own timeline as set forth in its sentencing statement, Chansley entered the Capitol at 2:14, but he did not enter the chamber until 2:52, meaning he was walking inside the Capitol at sometimes escorted by the police, at times alone as portrayed for 38 minutes before the door was opened for him to enter. Tucker Carlson stated that the videos were part of tens of thousands of hours of video. On March 9th, Dominic Pezzola, currently standing trial in the Proud Boys trial, filed a motion to dismiss the indictment in his case based on outrageous government misconduct, citing the exculpatory video referencing newly released CCTV footage by Fox News. The government filed their opposition. We've covered all of this in the Proud Boys case. In that opposition, the government made a very specific claim regarding the production in discovery of the CCTV videos. So this is a different case. Chansley is a totally separate case unrelated to the Proud Boys. Pezzola says, we needed that footage in our defense. The government didn't give us the same footage that we saw on Tucker's show for Chansley's case, and therefore they violated our constitutional rights to get exculpatory footage. The government responded to the Proud Boys, but Chansley's lawyer is using their response. Let's see how he does it. The government responded. They said the footage in question comes from the Capitol Video Surveillance System, commonly referred to as CCTV. The court will be familiar with the numerous CCTV clips that have been introduced as exhibits during this trial. They say the CCTV footage is core evidence in nearly every January 6th case, and it was produced en masse, labeled by camera number and by time to all defense counsel in all cases, with the exception of one camera where the footage totaled approximately 10 seconds and implicated an evacuation route. All of the footage played on the television was disclosed to Pezzola and to Chansley by September 24th, 2021. Footnote 1, we have a note here. In the videos, Pezzola and Chansley are shown together in video evidence because they were in physical proximity to one another, but there has never been any evidence that they knew each other, were part of the same group, or otherwise acting in concert. Chansley's defense continues. Says, on March 17th, counsel for Mr. Chansley sent correspondence regarding the Nordine case filing, requesting specific details and documents from the case. Government prosecutors responded, and the response shows that Chansley is likely entitled to the relief sought by this motion. But discovery is necessary to obtain material beyond what we got from the government. The response establishes that the discovery in the Brady material was not provided in a manner that meets the standard in this circuit for disclosure of exculpatory material. And further, the government's response includes representations that conflict with claims made to this court in other filings. All right. So we see here the government responded to Dominic Pezzola, and Chansley's lawyer, he's reading this and he's saying, what? Disclose here and disclose here? That doesn't sound right. You're saying in that case you did a thing, but in this case you did another thing. So he says discovery is necessary to determine whether and why the government misled this court and counsel during the year prior to Chansley's guilty plea, and then over approximately 3 months leading to his sentencing. about the production of this discovery. It would have been favorable to Chansley at sentencing. So we get some background here. On January 10th, so just to be clear, if we zoom out on this, it's a discovery problem, and the government is saying they disclosed everything, and apparently they didn't. Let's see how this came about. On January 11th, a grand jury indicted Mr. Chansley. A hearing was held. Fast forwarding a long time, September 3rd, Chansley enters a guilty plea. Paragraph E of the plea agreement allows for a collateral attack on his guilty plea based on newly discovered evidence. Okay, so a plea deal is like a contract between the government and a defendant and saying, hey, if you plead guilty to these charges, we're going to dismiss these charges. If you don't plead guilty, we're going to prosecute you on all of the charges, and we're probably going to ask for the maximum at trial when we win. And so you say, all right, well, if I plead guilty to this, will you dismiss all of these other more serious penalties and give me a benefit to doing that? Sure. But in the plea deals, in these contracts, there's a provision. It says what happens if something new comes about. What happens if we wake up tomorrow and it turns out that the cop who pulled you over is a liar, right? We find, that he's a meth dealer and he put it in your briefcase. Whoa, what? Does that mean I have to still be guilty? No, there are provisions in the guilty plea that say if there's newly discovered evidence or if there's ineffective assistance of counsel, something can be done to open and attack this current judgment and conviction. On November 17th, this court sentenced Chansley to a term of imprisonment for 41 months based upon the plea agreement that was entered by his other attorney. Undersigned counsel filed a motion and got admitted, and Chansley's other's lawyer was removed. So now let's talk about the legal standard here. This is referencing us over to the law. So let's put a pin in this and go actually read the law. The section that this lawyer is referencing is 2255, and we have that here, courtesy of our friends at Cornell. And they tell us the following. A prisoner in custody under the sentence of a court, which in this case would be Jacob Chansley, he's still under the custody of the court, claiming to be released upon the ground that this sentence was a violation of the Constitution. In this case, it's an illegal disclosure. He didn't get material that he should have gotten in order to make reasonable, intelligent, knowing decisions about his case. He didn't get the evidence that he needed. If that's happened, then it could be subject to collateral attack, and the person who is the victim of that may move the court to vacate, to set aside, or to correct the sentence. Now, we don't really know exactly what that means, right? What does that mean? Correct the sentence? So here's how it works. Unless the court just automatically receives this claim and says, wow, okay, that's egregious, and does something about it, the prisoner, in this case Chansley, is not entitled to relief. They don't get anything right there immediately, unless it's like so egregious the judge reads the motion and goes, whoa, and then just dismisses everything. But if it's not that high of a standard, the court shall then cause notice to go back over to the prosecutor, to the United States, and then grant another hearing to determine other issues. So to hold a separate proceeding where the different parties can make findings of fact, can make conclusions of law, kind of like another maybe mini trial. Not a full trial, don't even want to use that term really, but another hearing. If the court at the hearing finds that the judgment was rendered without jurisdiction, or the sentence was not imposed by law, or that there was a denial or an infringement of a constitutional right, or if it's open to collateral attack based upon ineffective assistance of counsel, which is authorized under the plea deal, if it's so bad as to render the judgment vulnerable to collateral attack, the judge shall vacate and set the judgment aside and discharge the prisoner, right? If it's so bad, the judge can just discharge. You're done, Jacob, you're done. You can resentence him and give him a whole new penalty. You can grant a new trial, says the law, right? Or you can correct the sentence as may appear appropriate. So pretty powerful ability here, but a very, very high standard, extremely high standard. And so it's obviously going to require a second hearing, and let's see how this unfolds. That's what the law looks like. And here they explain that to us. Here's what the court can do. They give us some case law. They talk about due process and how to prevail on a Brady claim. They talk a little bit about the ineffective assistance of counsel concept. And we're laying out all the rules. You see, all of this is case law, different citations that they are referencing. And so as we fast forward through this, here we go. We get some application. Now that we know how the rules work, they tell us, Chansley's lawyer writes, on March 6, Fox News and the host, Tucker, broadcast footage from inside the Capitol showing Jacob Chansley walk through a number of different locations. Officers are opening the door. They're even opening the door leading into the Senate chamber. On March 8th, 2023, Jacob Chansley's prior lawyer, called Albert Watkins, stated in a television interview he had never seen the videos played by Carlson. In fact, I think he was on the Tucker Carlson show. He said, they were not in the discovery I received. If I would have seen those videos, I would have done something differently about it. However, as noted above, the government responded to a series of questions posed by current counsel about this case. The government, in their response, they made specific representations about the CCTV videos. The pertinent part of the passage is captured below. You see what it looks like. This came from the prosecutor's office. Says global disclosures at this juncture were made through evidence.com, as noted in attached global discovery letters. The following cameras were uploaded to the defense instance of evidence.com on the following dates. So this is the portion of Tucker Carlson clips that was aired on March 6th. And they say specifically, defense team, you guys got this stuff. And it came from this camera, 0102, 0204, 0962, and so on. The approximate time that it captures the footage from J6, those are all listed here. The date the evidence was uploaded for review, many of those October. Only the last one, this one's late, February 21st, 2023. Global discovery volume, different listings there. So we see what it looks like. They're saying, hey, and it's like a receipt, right? Here's what you got. You pick up your documents. It's all listed in this. It's an index. Chansley's lawyer continues, saying the government claimed that all videos broadcast on Fox, except one clip of 10 seconds, were produced on evidence in global discovery 26 days before the sentencing hearing. Meaning the government says, we gave you everything 26 days before. But that claim is irreconcilable with what happened in the Proud Boys case just weeks earlier, in the case where the government claimed that Chansley had the videos on September 24th. So which one is it? Both representations cannot be correct. And it is quite likely that both are false. They say they gave it over on two separate dates. Between May 20th and October 25th, the government filed one letter and 4 status memoranda in this case regarding the government's ongoing efforts to comply with its rules under Brady. The memoranda was a 12-page memo containing detailed information about the efforts being undertaken by the government 7 months after Chansley's arrest to create a process for delivering discovery. We read through this here. Regarding the production of video evidence, the government stated, we are implementing and continuing. So let me just pause. Remember that in the early days of the J6 prosecutions, there was so much video evidence and so many defendants that the government didn't know what to do with giving them disclosure. And disclosure is a huge part of any criminal case. As defense attorneys, if you are not getting evidence, there is an opportunity for good recourse there, right? You can't defend your client without the evidence. And so the defense attorneys in the J6 cases were making all sorts of noise about it, and the government responded. They said, hey, we know there's a lot. We are implementing and continuing to develop processes to ensure the material gets disclosed. We're doing the following: comparing all known identifiers against tips, parlor data, ad tech data, cell tower data. We're searching all visual media, CCV, BWC, body-worn camera, and so on, right? This is all part of their explanation to the judge. The defense lawyer says, if one thing was undeniably true about Mr. Chansley on J6, it was that his Viking helmet with long horns made him easy to identify in the crowd and track him as he moved. The memo, filed on September 17th, 2 weeks after Chansley entered his guilty plea, made the following representation about the production of Brady material. It said in another filing, the government said in another filing, of course, there may be additional types of information a defendant may consider exculpatory, but since the government does not know the defense theory in any case, it's impossible for the government to determine other types of information a defendant may believe to be material. The extent of the type of information described above may exist. It may be interspersed among the data. Given the volume of the material and because the defendants are in a better position to review it, it's our intent to give you all the data and you can search for it. So, the government has so much material, they're saying we can't give you the exculpatory evidence. Exculpatory meaning it's going to show that you're innocent or lead to the conclusion that you're innocent. They say there's just tons of stuff. We're going to dump it on your front porch and you can look through it. Defense says this is an express acknowledgement that the government knew it was likely that Brady material was interspersed in the evidence, including in video evidence, and that it could not disclose the evidence in a favorable manner to comply with Brady. The government cited out-of-circuit authority in the footnote that's contrary to the standard in this court, suggesting that the obligation to uncover favorable material among voluminous discovery should rest with the defense. The question is, whose responsibility is it to go and investigate and find this exculpatory material? The government says it's the defense. The defense says, no, it's the government. You have it all. We can't rummage through everything. You've got to tell us if you've got it. You've got to disclose it to us, and that's in alignment with the Supreme Court. The status memo was represented to be an update. The same date that was cited in March 27th, they had a following update. They said the following video footage has been shared to evidence.com. Anybody who has a license can get it. 16,925 closed-circuit TV CCV files. You see how they do this? Consisting of approximately 4,800 hours over 4 terabytes of footage from 515 cameras located inside the Capitol Visitor Center. Yeah, we want all of that. Can you just publish that on the internet, please? Inside the Capitol Visitor Center on the Capitol grounds, to assist the defense in locating this, we have provided 15 camera maps and the interior of the Capitol. So they just dumped it all out there. 4,800 hours, 4 terabytes. And they don't make it easy to view it. 16,925 video files? What is the math on that? How long is each video file? You know how much you're clicking? You know how often you're clicking around on that? The production as described was 4,800 hours from 515 cameras. The memo goes on to state, among the documents, we expect future productions to include the remainder, 4,204 files, which is mainly comprised of footage that is deemed highly sensitive, i.e. footage of the interior of the Capitol. Saying that as of October 21st, this status memo filed with the court states that CCTV video from inside the Capitol had not yet been produced to the defendants. It was still subject to future productions because it was deemed highly sensitive. Meaning, Mr. Chansley and his counsel did not have the CCTV videos from inside the Capitol to use at his change of plea or at his sentencing. But the government did. And they knew they did. And they absolutely knew that that material was exculpatory. And they definitely saw it because they charged him. and they didn't disclose it. And it looks like they did not disclose it. This is not they just disclosed it and buried it in 16,000 files. It's they didn't disclose it at all. In its filing in the Nordine case, the government claimed that all the videos played on Fox News had been produced to the defendants, including Mr. Chansley, as of September 24th. But in its correspondence to me, the undersigned counsel, dated March 27th, the government claimed that all the videos broadcast by Fox were produced in global discovery on October 21st. But then in its status memo, dated October 25th, the government stated that only CCTV video footage from the visitor center and the Capitol grounds were produced, not the camera from inside the Capitol. So which is it? We don't think that we have it. You've said that you've given it to us in multiple different ways. So the basis for relief, they say that as noted above, the standard that exists here in this court means the government does not get to discharge its obligations under Brady by just producing global discovery that might have exculpatory evidence interspersed throughout. The government has represented to our client Chansley that the video evidence was produced no later than October 21st, but that claim appears not to be true. And so this court and the defendant, Chansley, are entitled to determine why the government has made multiple contradictory representations on this crucial issue regarding the timing of the Brady material. And the government had knowledge of this video evidence showing Chansley inside the Capitol. In fact, it used 3 segments from that video during the sentencing. They clipped out the other parts with the cops opening the doors, or with Chansley walking past a whole crew. The suppressed CCTV video is very favorable to Chansley. It would have supported a counter argument to be made at sentencing that responded to the narrative stitched together by the government. The defense counterpart would have been supported by this evidence contradicting the mischaracterizations by the government regarding any violent behavior and the failure of Chansley to follow police instructions. There were no instructions. They were walking around with him. And because this material was favorable to Chansley for purposes of sentencing, and it was suppressed by the government, Mr. Chansley's due process rights were clearly violated by the failure to produce the cameras from inside the Capitol. He continues to say that Attorney Albert Watkins recommended, based on this, that Chansley accepted a plea agreement tended by the government at a time when the government was telling the court and all defense counsel that it had not yet produced evidence related to this case. The plea offer by the government required a stipulation to an 8-level enhancement under the code. Without this enhancement, the level would have been reduced down significantly, less than half of what his counsel convinced him to accept. On November 15th, the government filed a notice of sentencing. In that notice, they identified 3 CCTV camera footages from that date. The filing of the notice of intent to use the camera video should have caused Attorney Watkins to request the sentencing be postponed to obtain all the video evidence. Watkins knew his client claimed to have been escorted around the Capitol. That claim is reflected by his second interview with the FBI, which was captured in an FBI 302. So Chansley, it's part of the file. So in other words, the defense attorney should have known about it, because he says that protester had already passed the police and entered the chamber before he even arrived. If Chansley's then counsel had not encouraged him to accept the plea prior to receiving the camera from inside the Capitol, the videos would have been a basis to not agree to the sentence enhancement. They would have shown Chansley was telling the truth about how he came to be inside the Senate chamber, that he committed no acts of violence, that he expressed no hostility, he had no intention to do violence to any property or any individuals. Says Attorney Watkins was ineffective, didn't get the cameras, and he was aware that the video was available because the government notified him they were going to use it at sentencing. By not securing the video and determining whether it supported Chansley's description, Watkins allowed the government to take liberties in describing his conduct without fear of the unproduced videos contradicting the government's claims. Could you imagine being these prosecutors and just snipping out that segment just to prove your claims? The following is one example of the government making use of its unilateral access to its video to favor their narrative. They said, armed with a 6-foot spear, the defendant brazenly marched past, this is what prosecutors wrote, marched past dozens of law enforcement officers with rioters throwing debris of all kinds at those who opposed them, past broken windows, through doors ringing with alarm bells. The defendant was among the first of 30 rioters to penetrate the Capitol building. He was waltzing around in there. They were opening the door for him. It's very dishonest. It's just dishonest is what it is. I understand being an advocate, an effective advocate and all this stuff, but they turned this man into something that he was not. The defendant then stalked the hallowed halls of the building, riling up other members of the mob, screaming obscenities about our nation's lawmakers. Ridiculous. Attorney Watkins was also ineffective by recommending that Chansley enter into an agreement to plead guilty to the most serious offense charged, agreeing to sentencing enhancements and waiving his appeal rights, all while there were still pending evidence in the case. But for Attorney Watkins' ineffective assistance, Chansley would not have entered into a guilty plea with stipulations and waivers demanded in the government's offer. An effective and competent defense attorney would have advised Chansley he could plead guilty to all the charges in the indictment without any plea agreement, preserved his rights to argue against the sentencing enhancements, and later appeal on an appropriate basis. So they're looking for further inquiry. He says that there is additional discovery that is needed. We want the opportunity to conduct discovery into these matters. 1, why did the government give inconsistent explanations 3 weeks apart as to when the CCTV videos that were played on Fox had been produced? And why were both explanations incorrect? Did the government and their production in global discovery, did it produce favorable video, satisfactory to satisfy the standard in this court? Why did the government falsely state that it produced evidence when it didn't? What decision-making process led the government to use the video footage from inside the Capitol during the sentencing? Were individual prosecutors on Chansley's case, or were any DOJ officials supervising this case? Love this question. Who else was involved in this? Were there discussions and deliberations within the DOJ about a plea deal? How high did that go? So in conclusion, based on the foregoing, defendant Jacob Chansley moves this court to vacate, correct, and set aside the conviction and grant him the right to conduct discovery with regard to the facts in this case. Submitted, William Shipley, defense attorney for Jacob Chansley. Excellent filing. Very curious to see what comes out from this because it does feel exactly right. The government has been hiding evidence and exaggerating the evidence in many of these cases we've covered. And I think as more of these things come to light and as more of these trials are laid out on display, the government's inconsistencies are a lot more easily identifiable. So we'll see what the judge does about this. Of course, we'll continue to follow. Thank you for subscribing wherever it is you're watching this, and we'll look forward to seeing you on the next one. But that, my friends, is it for us on the day. We covered some good ground here. A little bit of updates on the Chansley case. Donald Trump asking Congress for help. Jim Jordan sent some subpoenas out. Now it's time to hear from you and to see what you have to say about this from our friends on YouTube and our friends on Rumble. And I see a friend or two on Twitter and Locals, which we'll hop into. Who is in the house on this lovely day? Let's take a quick look. We had some questions come in. From Voice of the People. He says, definitely here for this one. I sent you an email for a bit of clarification on the Proud Boys trial. I want to bring it up tomorrow on your show called Off Label Podcast. Voice of the People, I think I saw the first part of that email. You're free to use whatever clips you need from this show. The other questions I think are more substantive questions, and I don't remember what they are. But have a tremendous show tomorrow, and check out my friends' Off-Label podcast, which will be streaming on YouTube. Lily says, Rob, I joined you on Locals, but it does not work for me. You, Megan Fox, Good Logic, all have Locals, and none work. The sound on Locals does not work properly for me. Rumble works. Well, Lily, first of all, thank you for joining our Locals. I'm so grateful you joined us. I'm terribly sorry it's not working for you. I'm wondering what the issue is. Can you send me an email and maybe we can diagnose this together? Yeah, we got to get some tech help. I need tech help too. Maybe we need some tech help. But just send me an email, Lily, robert@spotlightlawyer.com. And it might be an app thing. I'm not sure that I can help you. It might be an application thing. And I'm curious if you're on your PC or if you're on an app, right? Are you on an app or are you on a PC? But if you're having problems with our Locals and Good Logic's Locals, and shout out to Good Logic, and Megan Fox's Locals, it might be an app or a phone or a web issue. But we're going to try to sort it out with you. We've got a whole amazing group of people who are much smarter about this stuff than I am. And Lily, thank you for sending in the dono. And, you know, I feel terrible that you send in a super chat to get tech support. You know, it's kind of an expensive tech support super chat there. But we'll try to get you sorted out, Lily. Shoot me an email, robert@spotlightlawyer.com. Fred Petamonte says, Johnny asked, does Rob use gel or Gorilla Glue? Gosh, actually my hair today, I mean, I'm like smacking my face this whole show. My hair today is like falling in my face. It's like itching my face today. And then once you get a little bit of an itch on your face, you know, then you just can't stop itching. It's like one of those days. So it's not as stable as usual. And it's neither of those, Fred and Johnny Punk. It is mostly a blow dryer, actually. It's mostly a blow dryer. You just blow dry it up, and then I don't know what it's called. You know, some dry paste. That's all it is. And then what I do is I dip my whole head in plastic. I just have a big vat of plastic. I just dunk it in there. And then leave it around. All right. Thank you, Johnny. We have, I don't even know what it's called. I'm using something that my boy Sergio down the street gives me. I don't know what it's called. It's in a little jar. It's some fancy, you know, some fancy crap. I don't know what it's called. It's just on the shelf. And he says, that's the one. I say, all right, cool. Ian says, I would have thought the shaman would have had to basically sign his life away to get released. Well, he got sentenced, and he's already been released. Dude, this stuff is old. They're still beating this thing up. It's old. And he didn't do anything, you know, egregious, but he got a very egregious penalty, which is just awful. But fortunately, he's out. Hopefully, he's putting it behind him. And we're getting some good healing out of him and his family. All right, and let's see. Those came in over on YouTube, and thank you, everybody, for sending those in. I appreciate all of those. Let's see. We had a couple other messages. Hey, Maybe Sunshine is here. Maybe Sunshine says, just spreading the love. Maybe Sunshine is a member for 14 months. Woo, baby. Good to see you, Maybe Sunshine. And Maybe Sunshine gifted 10 memberships. Oh my goodness, Maybe. That's so nice of you. Thank you so much for doing that. It is very sunshine in here today. Now that you've invited 10 more people to join us. We got JC in the house. I think I know that name. Angie's here. Miss Jamie's here. We got Silent T, Mrs. Hayes. We got the Geninator, who is joining us. Shout out to Geninator. Tara joined us. Jason, Mimi, and Ace of Spades joined us. Good to see everybody in our new membership. And that means tomorrow morning, if you're a member on YouTube or if you're a member on Locals, we do member-only morning streams. And, of course, we'll be hitting that tomorrow morning on a lovely Saturday. And we had another super chat, I think, come in from our friend Fred Petamonte. Let's see what this one says. Says, can't have a functional government with this legal system. Tell me about it. Yeah, people aren't going to really have faith in the judicial system if the judicial system is collapsing all around us and becoming extremely politicized. Hey, Dolphin fans in the house, and invited 5 new members over too. Man, our chat is going to be lit tomorrow, courtesy of Maybe Sunshine and our Dolphin fan in the house. We got Alan, Saintly, Amber, Al, and Kelly in the house becoming new members, courtesy of Dolphin fan. Thank you, Dolphin. And Lisa Morrison also became a supporter. Lisa, we'll see you in the morning on YouTube. Amazing. Okay. Let's see. Okay, we had, I think that is it for us. Okay, let's see. All right, let's go over to Twitter and say hello to Rumble. Oh, we got locals too. We have a locals tip that came in. Oh, okay, this is great. Okay, so this was a big long message that came in. And so we're going to give a plug to Rubo Salt Shop, my friends. So Rubo Salt, the Rubos are part of our community at watchingthewatchers.locals.com. And they have an amazing, so they put together a great gift code for our members here. It's not affiliated with me. I don't get anything from it. I don't get any money or anything like that. It's just a nice discount for our community. Hopefully I can share this. Can I share this? I think we can share it. I think we can share it. If you go over to Rubo Salt Shop, it's this website right here. And okay, cool. And they have put together a discount called We Love Rob, which is super generous of them. And they have a discount. They have I think a tote bag giveaway. We're doing a giveaway contest for Rubo Salts, a canvas tote bag. We're inviting people to subscribe. So a couple people on our community have already ordered some Rubo Salt, and they love it. They've got it. This comes in a nice, beautiful package. I'm going to get some for my mama for, shoot, Mom, if you're listening, then you probably heard about that. But Rubo Salt Shop, and you can use code WeLoveRob, and people are getting it. It's coming in beautiful packaging. It looks like it's a ton of fun. And so go get yours, man. It's a great idea. RuboSaltShop.com. And shout out to the Rubos. The Rubos are in our locals community, and they are doing a good thing. And so shout out. Yeah, and stay salty, my friends. Yeah, indeed. So at the Rubo Salt Shop. Yeah, and then people are posting over on locals. Looks great. Looks great. So check it out. I'm looking forward to getting mine from our friends over and so that was on locals. You guys are great. Yeah. You guys don't need to send me anything. You guys don't need to send me anything. I don't need anything. You guys are great. I don't need anything. Get your salt, my friends. All right. So let's also say shout outs to Twitter and to Rumble. I'm going to order some salt. I'm going to order some. I like to support mom and pop salt shops for sure. All right. Let's say hello to Rumble. We've got La Azteca. We got Slightly Salties over there. Is that the Rubos? We got Dog Digger. We got What's a Woman. Mama Sari is in the house. We got A Job Well Done's over there. Sully 209. Good to see everybody on Rumble. We got a lively chat over there. Nick Danger, Jacob Castro, Eric Scorpio. Says Rumble meant something in the 50s. Yeah. All right. So, okay. Good to see everybody over there on Rumble. Yeah, we got 560 watching over there. Woo. That's great, man. The chat is lively. Member of the public is right there. Hail the Rumble ghetto, says Jacob Castro. Okay, awesome. It's good to see everybody over there. Hey, quick update on the Proud Boys case before we get out of here on the day. This is from Roger. The jury in the Proud Boys case is recessed. Its Friday deliberations will resume on Monday, so no verdict today there from the Proud Boys. No verdict there. And then let's see what else is going on over on Twitter. See if we have any comments over there before we go over to our after party at watchingthewatchers.locals.com. And if you're a member on YouTube, don't forget to grab the Telegram link. The Telegram link, which is where you can join us for the after party. All right, James Pepper sharing this meme, and this human is with a real good boy. They're out there looking for something, and he says, so exactly what did this Roadrunner do to you? I don't want to talk about it, Brad. Good call there from James Pepper. It's a piece. He's just looking through the, it's peaceful. All right, we have James Pepper, and Danny McWilliams says, I said it before, I'll say it again. There's no justice anymore. If the FBI is involved, run. Adam says, Jim Jordan is really turning the screws and getting some answers. So those are some good comments over from Twitter. Thanks for following us over on Twitter and supporting the free speech platforms over there. But that, my friends, is it for us. And we are done for the day. I think we missed one. Thank you, V. It says, Rob, have you further looked into the CRS firearms case? I'd love to hear your take. Great show with some lovely ladies in the chat. Whoa. from Riley Leifson. The CRS firearms case. No, I don't think I took a look in that one. What is that one again? I was looking at some other. I haven't looked at it hard enough to reference it as a CRS firearms case. CRS, okay. The auto key card case. Is that what that is? Yes. Federal jury convicts 2 men 8 days ago for conspiring. I guess, what's my take going to be on it? All right, I have it pulled up. Let me read it. If I have a take, I'll share it, but I don't know that I'm going to have a take on it. What am I going to say? The DOJ is a disaster? It's garbage conviction? I can tell you, I don't even know much about it. That's going to be my take. It's crap conviction. The DOJ sucks. But I'll look at it. I have it pulled up here. It's over at justice.gov, April 21st, out of Jacksonville, Florida. Auto key cards, conspiring to transfer unregistered machine gun conversion devices they refer to as auto key cards. 7 counts transferring unregistered machine guns. Part of a project. Yeah, I'll look at it. Doesn't look good. And Tanya's over on Locals says, it was too funny when leaf blower guy showed up when you were on the interview this morning. Gosh, this morning's interview with Allison. I apologize to Allison and her audience. It was not, my sound was not working. And then right when the sound came back on, my microphone went back on. As soon as we get recording again, leaf blower guy shows up. I'm like, oh my gosh, this is a disaster. But we made it through, and she was very nice after the show. Absolute professional and very nice and understanding. So we made it through. We had a great time. Shout out to Allison. And thank you, Tanya, for commiserating with us. It was fun. It was just like, oh gosh, all right. I was waiting for her to just say, we're done. You're canceled. You're uninvited. Don't ever come back to my show. But we made it through. But all right, my friends, that is it for us on the day. And of course, we are going to leave it right there. If you're a member, come on, join us at watchingthewatchers.locals.com or on YouTube. Click the community tab on the YouTube button and join us on Telegram, because you're going to be able to continue to watch when you join us over there. Also, don't forget to get your Field of Greens courtesy of our friends over at fieldofgreens.com. Save 15% with code Robert when you check out. The vegetables want to be eaten. Also, don't forget your Rubo salt. So rubosaltshop.com. Use We Love Rob to save 15% at checkout. And that is a great gift for mom. Field of Greens or some Rubo salt. Either which way, get yours today. And if you like the mind map, check out the mind map at spotlightlawyer.com/mindmap. If you want to use this for personal projects or organization, I'm using it for some other things I'm working on that I'm looking forward to sharing with you at some point. But spotlightlawyer.com/mindmap to get a free account. Also want to thank the mods who mod down the fort for us, doing an amazing job helping to keep things nice and orderly. The Antikiss Prime. We've got KB, Just Cause, Playin' Hooky, Ronnie Cole, Zulu, Geomancy, Zach Nichols, our friend John Allen, Janek, and Dog Digger, along with Donut Mind Me. Shout out to our meme smith, Sleepy Dog Lee, and Geegum Geegum in the house. And so that, my friends, is it for us on the day. We are going over for our members only debrief and after party to hang out for a little bit longer. I hope to see you there. But if not, my friends, it's been a busy, busy week. We wrapped up with the Proud Boys. We picked back up with the Trump civil case. We'll be back next week with more verdicts, maybe more trial, cross-examination from Joe Tacopina and others. We'll see what Congress is up to. But until then, it's a lovely weekend ahead of us. It's a great time to unplug, rejuvenate those batteries, get some vitamin D, some fresh air, some sunshine, spend time with friends and family, because we got to be back here next week to do it all again, baby. And we're going to be fired up. And I hope to see you here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Have a beautiful weekend, my friends. See you right back here on Monday. Make it a great night. Bye-bye.